Hey Sexies, my name is Bailey. I'm a 23-year-old law student in Washington, D.C. I love history, I love law, and that's why we're here. Before we get into it, let's get into some background. In my last semester of college at Texas Southern University, I was doing my capstone research, and my professor was talking to me about this history and law course that they wanted to offer within the history program, but they didn't have anyone with the credentials to teach it. And I'm telling her about how I want to go to law school and I want to do all these things. And she was like, get that JD, come back to TSU and come teach this class. And ever since she told me about it, I genuinely have thought about it every day ever since. Flash to a couple weeks ago, I see this post on Pinterest that's like, don't give up on something you think about every day. And now we're here. Since she's told me about this class, I thought a lot about how these two things connect. I've done a lot of research about it, and I thought, what would I teach in the class, assuming that I do have the position? Where would I actually take it? And that's why we're here. While I am a student and I'm learning as well, I feel like each one teach one, why not share? And let's see what we all learn together. You know, if you see me looking down, we're looking at notes. This series, like I said, is about history and law as two disciplines and how they connect, the intersection between history and law itself, as well as the realm of legal history. Legal history is a relatively new discipline, but it's still distinct in its own right. Everything gets its own moment here. All three of these Birkins are their own thing, but here we talk about how they connect. So let's get into it. Let's start with some building blocks. Merriam-Webster's dictionary defines history as the chronological record of significant events, often including an explanation of them. Black's Law Dictionary, just a popular legal dictionary, defines law as the regime that orders human activities and relations through systematic application of the force of politically organized society or through social pressure backed by force in such a society. Generally speaking, we all know what history is as a discipline, as its own subject, and we know that the law is a governing document, a governing piece of principles that we as a society abide by with social pressure, with political pressure, with consequence. Whatever is used to reinforce it is used to keep people acting how their government wants them to act, right? Then there's legal history. Legal history is defined in Black's Law Dictionary as the branch of knowledge that records and explains the events within a system of law or systems of law, generally as steps in the progress of civilization. Or it's defined as the events that form the subject matter of this knowledge, or a treatise that systematically presents these events, usually together with a philosophical explanation of them. Kind of sounds like the two definitions put together. The laws that create the society and the record that explains them, right? So if we know that all of these Birkins are their own thing, where do the connections come in? Legal history is already the child of history and law, which is why I feel like she should be included here. But I just think that the connections are a little bit more nuanced to just say legal history, period. That's why they're all included here. And like, if that was, you know what I'm saying? I have ADHD. Sometimes I don't explain things as well as I should. We're getting better. History, law, legal history. My three Birkins. How are these Birkins connected? The overarching theme of this episode and connection number one, law as record. The most immediate connection that law and history have is how the legal codes or legal records serve as historical records. A society's legal code can tell us so much about the society at that given time, what the governing body was thinking when they were writing it and constructing the society for that given time. It tells us about the people in that community, who are they trying to regulate, who composes the society, and in application, we learn even more about the society at large. Let's think of America as a quick example. Our laws are drafted by our elected legislature, let that be Congress with the House of Reps and our senators, or whether it's state legislatures that you vote in through local and state elections, assuming that you vote in local and state elections. Then the people that you vote in, who ideally you vote because they align with your principles, align with your politics, what have you, you vote in these people and they write the laws that are deemed most needed for your constituent base, for that state, for the people, whatever. American laws over time have shown me a couple of different things. Our laws can be a little reactive. Sometimes things have to happen for our legislatures to be like, oh, maybe we should regulate this. Maybe this is bad. But sometimes our laws also show what we are not regulating, what society does want to have. People have been screaming gun reform for years, but that Second Amendment still rings true to this day. Sometimes the law doesn't always reflect what the people want as much as it reflects what America is a case study. That's the point of this part of the video. In America, our laws reflect a very diverse group of people. We have laws reflecting all different types of topics, whether it's agriculture, whether it's medicine, whether it's food and drug regulation, all of these things, not even including the different types of groups that are being regulated within the law. When we're talking about racial demographics or gender demographics or socioeconomic classes, all of these nuances in our society are reflected in our laws, whether they're reactive or not. And for less democratic societies or with more concentrated governing bodies, this is also reflected in their laws. These legal records show what that society looked like at the time or what the government was trying to establish. Then you reference other historical records like diaries, photos, things like that to see what application really looked like. Was society reflecting how the government wanted to? Was society taking to the laws and the structure that was created for them? How was it going, you know? A great example of how a legal code can reflect a society, its functions, its nuances, and all of its inner workings is the Code Noir. This code is intended to regulate what enslavement looks like in colonial France and in their territories. So it covers a range from marriage, family, property, contracts, who can be a party in a suit, who cannot be in a party in a suit, a wide range of topics to cover most aspects that they could cover of social life. Major themes from the Code Noir show that Catholicism was a dominating tenet in colonial France. Only the Catholic religion was allowed in the Code Noir, and any other religious practice was forbidden. Marriages were only considered valid under Catholic practice. All enslaved persons had to be baptized and taught under Catholicism. We're seeing the picture. Another major tenet was the role of the enslaved and how they were viewed. The law defined the enslaved as property, and specifically movable property. Think similar to livestock or to furniture. The enslaved could be divided, gifted, inherited. They could be bought and sold. Real people treated like livestock. Enslaved people of different households, regardless of the reason, could not gather or there would be physical consequences, and there were very harsh consequences for those who were runaway slaves. First offense would be their ear cut off and they would be branded on the shoulder with the fleur-de-lis. Second offense would be the hamstring was severed with the fleur-de-lis, another brand on the other shoulder. And the third offense is death. The code allowed for such harsh physical punishments for the enslaved, and on the back end would try to regulate masters saying you can't mutilate or put in such harsh torture onto your slaves. Was it enforced this way? Masters also weren't allowed to force their slaves into any unions that they didn't want to be in. Was this also enforced? And among the other rules in the Code Noir, there were regulations and laws for the freed people of these colonies and in colonial France. The affranchis were allowed to have some regulation and mobility within their life under the 1685 Code Noir. From another perspective, the 1685 Code Noir shows the rebellious acts of the enslaved, and it shows a different perspective of the society that this law was regulating, but that is a different episode for a different time. 1685 Code Noir tells us a lot about colonial France and about their territories, mainly that Catholicism was a dominating part of their society. The interactions between the enslaved and free people, or enslaved and their masters, were not so much dependent on race, maybe how it would be in America or under American chattel slavery, but has a lot to do more with power and with class and a little bit with religion. The 1685 Code Noir tells us that colonial France and their territories were focused on promoting enslavement and making sure that it was well regulated to their liking, not necessarily focused on race relations or specifically on economics, but Catholicism and religion was a dominating factor. The way that people were treated and allowed to be treated under the Code Noir shows an intention in some kind of social structure, some kind of hierarchy. There are ranks of power as you go up the hierarchy. There are the enslaved whose lives are regulated to a T. There's the affranchis who have some power as freedmen. And there are citizens of colonial France. There are people who have always been free who have these different powers and privileges under the Code Noir. As a French territory, the Code Noir was extended to Louisiana in 1724. The intention of the code to regulate slavery in the French territory was not different when it came to Louisiana. The location of Louisiana and its inhabitants made the code different. most of the laws didn't change, and its harshness only got harsher. A major difference between the 1685 Code Noir and the 1724 is its laws on interracial marriage. The 1724 code bans interracial marriage when the 1685 law never mentions it. The only regulations they had, as we discussed, were making sure that their marriage unions were under Catholic practices to be valid under their law. In Louisiana, under the Code Noir, no interracial marriage was allowed, period, regardless of what religious practice you bring your marriage in under. The major difference between the codes was their laws on emancipation. In the 1685 version, a master could emancipate their slaves by signing away their permission, but in the 1724 version, it was an additional bureaucratic step that was added where instead of it just being a master's written approval, they also had to get permission from a superior council or their local government to have the emancipation be legitimized. The 1724 code also had more restrictive laws for those freed from enslavement, trying to cut down on maroon societies or freedmen societies, which is a sharp distinction from the 1685 code. The Code Noir is a great example of how law serves as a record of a society's happenings, its intent, how it ultimately manifests because of a few different reasons. Across the board, the institution of enslavement in colonial France was meant to be harsh, it was meant to be painful, and it was meant to be a very rigid social structure for one class to be on top and one class to be on the bottom. But the way it applied across these different territories tells us everything about what their society looked like. In colonial France and in the Caribbean territories, there wasn't the nuanced factor of race being a very prominent factor in enslavement compared to being in Louisiana. Even if they were a French territory, they're located geographically in the Americas. The code never changed from colonial France to the Caribbean territories to Louisiana, yet the way it was applied from the 1685 version compared to 1724 is quite different. It tells us the inhabitants of these societies are different. The culture and the norms in these societies, though were intended to be the same, manifested in different ways. Because Louisiana was undoubtedly influenced by America and the things that they were doing with chattel slavery, we see a higher prevalence of race relations and their laws being more race conscious, i.e. anti-interracial marriage laws and no reference to Native Americans, despite the fact that the French colony is located in America. The Louisiana Code Noir versus the 1685 Code Noir also tells us there's a major push on keeping enslavement and really reining in the maroon societies or the happenings of freedmen. The original code allowed the freedmen of these colonies to have some rights and to have some privileges. The 1724 Code Noir said we're not having that. After the Louisiana Purchase, we see Louisiana form their own black codes and their own culture, but the influence of colonial France and just the influence of France as their dominating power for quite some time was still there and it's still there today. The impact of a society's legal code doesn't stop within that era or within the geographical bounds of that society. The way that a government chooses to run and structure their society does not go unnoticed by other countries. The best example of this is Jim Crow America and Nazi Germany. If you came from my TikTok, you already heard this mini breakdown, so we're really getting into it. As a historical record, what do Jim Crow laws tell us about America at that time? Let's timeline it. So what's happening in America at that time? 1619, we have the first slave boat landing in America, marking the beginning of chattel slavery, the institution in this geographical area, right? 1776, we have the American Revolution, so we technically weren't even in America in that whole time. Then 1861, we have the start of the Civil War, which lasted through 1865. What happens in between that time? We have the Emancipation Proclamation in 1863. Then we have Juneteenth, because you know the emancipation of slavery was quite gradual. Then we have the ratification of the 13th Amendment in December 1865. Now, is this upside down? Oh, immediately after the 13th Amendment comes what? Black codes. After about 10 years of black codes, we see Jim Crow coming in 1877, and we don't see the end of Jim Crow until 1965 with the passing of the Voting Rights Act. There was a lot of gradual change. We saw Brown v. Board in 1954, but we don't really see a hard stop until that Voting Rights Act. From my perspective, these laws reflect a de jure means or a legal means of reflecting the de facto setting, what society is already showing. I show the timeline to show that the framework for Jim Crow America was being built from the moment that slave ship landed in 1619. From 1619 to 1776, the social fabric of this country was coming together before legally the country was established itself. So, come 1865, at the end of the Civil War, it's not surprising that the government and a large part of the country is fighting to maintain this social status quo that was building the country before America became America itself. These laws allowed for a legalized, fully segregated society. We see a wave of anti-interracial marriage laws. We see the incorporation of sundown towns, housing discrimination with redlining, restrictive covenants as a means of racial segregation, racial zoning ordinances. We see voter discrimination with poll taxes, literacy taxes, the grandfather clause, the white-only primary, and lots of segregated spaces, schools, public parks, cemeteries, water fountains, movie theaters, buses, and general public transportation. This is going on for 9 decades, from 1877 until 1965. This was going on for almost 100 years. So what does Jim Crow show us? A growing world power at this time with a very nasty underbelly, one that's fighting very hard to keep up their segregated status quo, to keep up the same social structure they had before the country even became America. In this 9-year period that Jim Crow is looming over America, there's a lot of things going on in the outside world, and one particular growing nation was watching what was happening in Jim Crow America, and those would be the Nazis. I won't keep referring to them by name, so we'll just call them the Ns for the rest of this video. As I said, Jim Crow laws were ranging from 1877 to 1965. In 1919, the Ns kind of started brewing up in their part of the world. In their 26-year run, and I'm sure in the time leading up to it, the group was paying well attention to how America was running their country, and they liked what they were seeing. In Hitler's American Model, James Whitman goes in depth on how Hitler and the Ns were inspired by Jim Crow America, how they legally disenfranchised and discriminated against Black Americans to the point of a fully segregated society. Whitman explains how Jim Crow was viewed as a very suitable program for their goal, but it wasn't harsh enough to invoke the kind of social change they wanted to create, so they looked deeper into American laws to see how they disenfranchised other marginalized groups. Specifically, the Ns looked to the insular cases to see how America disenfranchised the territories that they attained during the Spanish-American War by not extending constitutional rights and protections to these territories that America ultimately adopted. You force us to reign under your country, but we can't have any rights. History fact, have those laws been overturned? No, they have not. The Supreme Court had an opportunity to in 2022, and they declined. The Ns did bite off Jim Crow laws, specifically with the one-drop rule and with the anti-interracial marriage laws that they invoked within their Nuremberg laws. The segregationist policies and culture that America was invoking in Jim Crow was very much being bitten off and remixed in Germany in ways that make my stomach hurt beyond belief. There was even a point in 1935 when 45 lawyers were gifted a trip to New York to see how the laws run in real time. These lawyers were gifted this trip for codifying Hitler's new regime and establishing this new social order through their laws. And they come to New York to see if they're really biting off the original. Are we doing it right? How a government is building its society through its legal code is not restrictive to that society or to that era. And this is very clear with Jim Crow and with Nazi Germany. Jim Crow was years ahead of in Germany, and yet we see reflections. And this is not the first time that America has impacted in Germany, not the other way around. At that time, Americans spoke out very negatively against in Germans, but the in Germans were like, we do what y'all do, so what do you mean? Jim Crow America and in Germany are a great example of how one society and the way they choose to structure themselves and create their status quo can have life-altering effects on another society and how they choose to establish themselves. Even at the end of in Germany's reign, when everyone's being prosecuted for their crimes, they're still looking to American law to justify what they're doing. In the doctor's trials of 1946 and 47, during the trial of one Karl Brandt, his attorney used Buck v. Bell, a Supreme Court case in America, as defense for why they were conducting sterilization. The Supreme Court in Buck v. Bell allowed for a state law that authorized sterilization for those with disabilities, and it allowed for a wave of sterilization laws in America. In his defense, Brandt's lawyer references Buck v. Bill as a way of showing another major world power that sees no issue with sterilization. Why is he going to jail when nobody in America is getting in trouble for this? It really goes to reinforce that universal tenet that you never know who's watching and you never know who you have an influence on. It's very scary to see how we have influenced, not I, how America has influenced some of the worst atrocities that have happened in history. And yet we don't say too much about that, you know? When we look at this intersection between law and history, being legal history and maybe things outside of that field, we learn a lot about sociology, about how societies emerge and how they change, about how they influence each other. We learn things like narrative framing, who laws are meant to serve, and all of these different types of influences, how the law and history meet. Today, this intersection showed us how law and history reflect a society's growth, both legally and socially. Aside the fact that history does repeat itself, I also feel that the laws are intended to mold or ferment a society. Whether it's Jim Crow America and the laws are created to reinforce a status quo, or whether it's the Code Noir and the laws are created to create a framework for both the colonial empire and its territories. We're seeing what their intentions are, and we're seeing how these intentions manifest in application. We use the Code Noir to show how a legal code can reflect a society's happenings and how people engage with each other and what the government wanted for their society to be. Further, we talk about how these legal records impact each other through the domino effect, how one society's laws and the way they chose to structure themselves can influence, for better or for worse, another society. These are only two examples on the intersection of history and law and the things that they can teach us, and I have many more to share, and I hope that y'all want to hear them. There's more history and legal history coming, particularly to this channel, but definitely go to my TikTok and my Instagram if you want to see more history facts, if you want to see more law school journey stuff, or I don't know, if you just want to support the queen. Stay sexy. Hope y'all end up loving history as much as I do. See you next time.